On December 7th, the Boston Herald reported that police were investigating whether violent and sexually suggestive media could have played a role in inspiring LaPlante to commit murder, because investigators had found numerous pornographic magazines all over LaPlante's bedroom. This idea that violent media could be responsible for the violent actions of those who consume it had a large place in the investigation. Even today, this idea is very prevalent in society. In addition to the magazines found at LaPlante's house, they found several torn porn magazine pages in the wastebasket of the Gustafson master bedroom. LaPlante had told police that on the day of the murders, he'd been home watching MTV for much of the day. So police decided to comb through what had been shown that day to see if any of the videos or shows depicted violence, perhaps against women, that may have inspired LaPlante. They also wondered if he'd perhaps been trying to recreate something he'd seen in an explicit magazine. Hi, I'm your host, Zach Williams. Welcome to Compulsion. In prison, LaPlante was moved to protective custody within a week. The other inmates were being hostile towards him because his crime involved children. And on December 11th, the news broke that the murder weapon had possibly been found, in possession of LaPlante's stepfather, David Moore. However, authorities quickly corrected the media when they realized that this was not actually the .22 semi-automatic. Rather, the .22 caliber Ruger revolver that had also been stolen back in October from the Pincel household. David Moore claimed that he had found this gun in Daniel's hamper while washing clothes at a public laundromat. Apparently, it fell out onto the floor when he went to put Daniel's clothes in the washer. This was about a week before the Gustafson murders. David kept the gun at his work in a tool chest to, quote, keep it away from Danny, according to the Boston Herald. He yelled at Daniel and scolded him, but believed him when LaPlante said he'd stolen the gun over a year ago, before he went to the detention center for the Pepperell incident. They didn't report the gun to authorities, as it would have been a parole violation for Daniel. This took place about a week before the Gustafson slaying occurred. And David and Elaine asked LaPlante if there was anything else in the house he had that shouldn't be there. He told them there was not, and they believed him. Reports differ on the circumstances surrounding why the gun was turned over to authorities. The Herald says Moore turned it over when the police got a warrant to search his tool chest at work. The Globe says that David moved the gun to his brother's house quickly after he found it, but his lawyer advised him to turn the gun over when David noticed he was being tailed by police. He'd allegedly told his lawyer about the gun as soon as he had found it. The gun was turned over a week after the murders on December 11th. Elaine later said that she and David hesitated to turn the gun over to police because they were worried about getting in trouble. During a second and third search of the house, some of the items being searched for were not made public at the request of the defense. Presiding Justice Travaline agreed that making the list public could lead to speculation. After the search, however, the police released their findings. They'd found a substantial amount of .22 caliber ammunition, a fishing knife, and numerous hairs and fibers that needed to be analyzed. Meanwhile, forensics had found substantial evidence at the Gustafson house as well, and on December 15th, Judge Joseph Travaline approved a request to obtain hair samples from LaPlante, because there was a pubic hair found on the Gustafson bed that did not match any of the family. On December 23rd, LaPlante's attorney Robert Casey told the media that he believed multiple people were involved in the Gustafson slayings. He asked anyone who knew anything to please come forward, saying, quote, "It's imperative to avoid a miscarriage of justice." He said he'd received a promising tip about the case and, quote, "I have reason to believe that there are individuals that know more about this case than they have made public. I wish these people would come forward." Police Chief William May responded to this by telling the media that Casey had not come forward with any of this so-called new information. Quote, I have said from the beginning that we would appreciate any information in this case. If Mr. Casey has information relative to the investigation, we would certainly appreciate his coming forward with it. Whatever suspicions Casey had were not further elaborated on, and no one came forward with information. A week later, on December 28th, the Boston Globe discussed overhauling the code for charging youthful offenders, which at the time had remained largely unchanged for 81 years. They pointed out that the 10 months LaPlante spent in legal limbo were not at all unusual, and that it was common for young offenders to be locked up for months or even years at a time, while legal teams fought over whether the child could be tried as an adult. The average wait time was 8 months for felonies. Also, according to the current juvenile code in Massachusetts, anyone over 17 is automatically considered an adult for sentencing purposes, and their cases are handled exclusively by the adult court. For minor crimes, though, the system often goes the other way and moves too fast. Youths accused of minor crimes are often given a lawyer the day of their hearing and given no time to prepare any kind of defense. In smaller courts, youth hearings are only held once a week, but are frequently postponed due to scheduling conflicts, which can drag a trial out for months without any actual continuances. This overhaul would include a need for fewer continuances in general, as well as the possibility to keep youthful offenders in treatment centers up to the age of 21, because they are currently released at age 18 in most cases. LaPlante returned to court January 8th for a probable cause hearing after being evaluated at Bridgewater. Joseph Traveline had not yet made a judgment on whether or not LaPlante was competent to stand trial, but he heavily implied to the media that the initial psychiatric evaluations had determined LaPlante competent. He also ordered for samples to be taken of LaPlante's hair and blood to compare to evidence at the scene. On January 13th, the Boston Herald reported that LaPlante was facing 28 charges, 10 of those from the Pepperell incident. Even though the Herald had been the only paper to interview the Bowen family, this article claimed LaPlante had held a family hostage for 2 days. Just weeks into the trial, the Herald was already beginning to report inaccuracies, and the Globe shifted to being the more reliable of the two. In March of 1988, Robert Casey went to court to determine if representing LaPlante would be too great a conflict of interest. Casey was the Moore LaPlante family lawyer and had represented LaPlante's parents and brother in legal matters before. He was friendly with them, and they were all going to testify or be examined by the prosecution. But LaPlante told the judge that Casey was the attorney of his choice, no matter what conflicts of interest were present. At this point, the case had been moved to Judge Robert Barton presiding, and the new judge elected to allow Casey to withdraw from the case. The next month, on April 6th of 1988, Michael Pulaski and Stephen LaPlante found the stolen .22 caliber revolver in the glove compartment of a junk Jeep in their backyard. They called William May at about 2 a.m. the next day to tell him of the discovery, and May rushed over. Though the police had searched the house 3 times, they'd apparently failed to find the murder weapon. Elaine later told the Boston Herald that she was baffled about how exactly police could have missed it. The searches of the house and the grounds it was on had been extremely thorough. A ballistics expert confirmed that it was indeed the murder weapon used, and the shell casings matched both those found at the crime scene and one found in the LaPlante family home cellar. When later giving testimony in court, neither Stephen nor Michael elaborated on why they'd been searching the junk Jeep, and the defense did not question them about it. The case fell out of the papers for a bit until June 15th of 1988. The Boston Herald wrote an article saying that LaPlante had written to a pen pal in prison, one Larry Brocklebank, who was attempting to befriend LaPlante and offering legal help for the case. LaPlante had written back to him on at least 3 occasions. One of the letters said, quote, "I received no info on what evidence the state police have. They have no gun yet and never will find it. They won't find the gun. I was alone." The authenticity of these letters would later come into question, and the dates they were supposedly written were not given. If they'd been written after the media broke the news that the murder weapon had been found, it could expose them as fakes. But none of the postmark dates were ever given to the media. On July 11th, LaPlante's new attorneys, David Duncan and Robert Shiketoff, were still fighting the prosecution on collecting hair and blood samples. Tom Riley, with the prosecution, said, quote, "There is a probable cause to believe that a sample of the defendant's pubic hair will produce evidence relevant to the question of the defendant's guilt or innocence." The prosecution was also trying to obtain handwriting samples to determine if the letters that Brocklebank had claimed to have written to LaPlante were genuine or not. Despite the new defense team's efforts, Judge Barton ruled in favor of the prosecution, and they were allowed to collect their samples before the trial began. On September 8th, Judge Barton ruled that LaPlante would be charged first on the 3 counts of murder, as well as breaking and entering the Gustafson home, and the lesser 23 charges would be dealt with after, the possible rape charge included. Though the prosecution was not pursuing the rape charges, they were not barred from speaking about them in court. LaPlante's defense team tried to argue that the trial should be moved out of the local court. Andrew Gustafson was the only lawyer in town besides Robert Casey, and he was very familiar with everyone in the local courts. Plus, the case had been all over the local papers, and everyone in the surrounding area had been following it. Barton ruled that the hearing would happen in Lowell, but was open to bringing in a jury from further away, who may have had less media exposure to the case. In mid-September, 4 more letters were seized by Judge Robert Barton, and the media was able to put together more information surrounding the circumstances of the letters. Brocklebank had written to LaPlante saying that he wanted to be his friend, and he had even said that he wanted to have his lawyer help out with the case. From the first letter, Brocklebank was already talking to the Middlesex District Attorney's Office. Brocklebank had told the DA's office that he could get useful information from LaPlante, but in exchange, he wanted a reduced sentence. He met with Joe Lawless in early January and showed him the first 3 letters. Lawless later testified that he'd only promised Brocklebank that he would help him get into a drug program and help protect him from the other inmates, as they were suspicious that Brocklebank was offering information to the guards in exchange for special treatment. He'd also said that he would put in a good word for him and possibly help him get transferred to a better facility. Then Lawless told Brocklebank not to write LaPlante anymore because, quote, "I didn't want it to seem as if the DA's office was communicating with LaPlante." Brocklebank and his lawyer had other ideas and wrote to LaPlante asking several questions, including, quote, "Do you know where the gun is? If so, where? And why did you have sex with the lady? Was it before or after she was killed?" He went on to offer to have his lawyer find and dispose of the gun, and said that he could get Daniel into a better hospital. He also insisted that his lawyer had a few politicians in his pocket, and said he hoped that Daniel would, quote, "learn to trust me." Some of the letters indicated that the lead prosecutor, Thomas Riley, had already worked out a deal with Brocklebank. When Lawless visited again, Brocklebank had 4 more letters, but Lawless didn't open them, and brought them to Barton when he ruled the correspondence could be relevant. On September 20th, the Boston Globe reported that a random search of LaPlante's cell turned up a copy of the New Testament that had Brocklebank's name and the address he could be written to in prison. They also found a piece of metal being shaped into a handcuff key. LaPlante had 2 other pieces of metal that were being sharpened into shanks. The fact that LaPlante did have Brocklebank's address lent some credence to the authenticity of the letters. The same article included more information about the letters. Brocklebank had apparently written to both Lawless and Riley about a deal they had made, and scolded them for not keeping up their end of the bargain after he had gotten LaPlante to incriminate himself. In court, Riley denied having any involvement, and Lawless maintained a consistent testimony. Lawless also mentioned that Brocklebank had done this before, and traded information about his fellow prisoners to get out of jail in Florida. The next week, on September 26th, Judge Barton denied a motion to suppress evidence gathered from the LaPlante family home. The motion had tried to argue that the warrant was for a single-family home, and the LaPlante family home was technically a two-family structure, as Stephen had his own section of the house that technically was its own dwelling. The next day, the 4 letters written after Lawless had told Brocklebank to stop corresponding were thrown out, as well as the statements LaPlante had made immediately after being arrested, but before being read his rights. However, Barton ruled that if LaPlante wanted to take the stand in his own defense, the prosecution would be allowed to question him about the statements he'd made to his arresting officer before being read his rights. Jury selection began in October, with almost 300 people from nearby towns to be interviewed and questioned. It was whittled down to a panel of just 16 jurors. On October 6th, the jury was bused to Townsend. They were expected to stay in a nearby hotel for the duration of the trial. They were not permitted to correspond with family or watch or read the news in any form. Before the trial, the jury was taken through the Gustafson family home and shown the site of the murders, the bed where Priscilla's body was found, and the bathtubs where the children had been drowned. Then they followed a trail of red police tape that traced the path that the tracking dogs had taken. The jurors hiked through the woods to the LaPlante family backyard. Then they were taken all over Townsend, and they visited the homes that Daniel LaPlante had broken into prior to the murders. They stopped by Pepperell to see the Bowen family home, and then they traced the route LaPlante took when he was on the run. They visited the homes that LaPlante had broken into or attempted to break into during his flight from the police. Then the jurors visited Ayer Industrial Park, where the police chase had come to a halt. The trial kicked off on October 8th. Over the next 3 weeks, the prosecution called numerous witnesses and forensic experts to the stand, while the defense largely relied on attempting to refute what was being said by the prosecution. The prosecution opened with testimony from a 9-year-old girl. She said that she had heard screams coming from the Gustafson family home during the time of the slayings. That day, she and Abby had walked home together from the bus stop, as they were neighbors. The girl had said goodbye to Abby and then went home. She set her backpack down, then immediately joined her sister outside, who was chasing their pet rabbit who had gotten out. While the girl was running outside near the Gustafson home, she heard a scream that she later said sounded like Abby, as well as a dog barking inside the house. She said the scream lasted about 15 seconds. The next day, Andrew gave his tearful testimony that's previously been quoted, about coming home to find his family dead. Many of those in the jury shed tears with him. On October 11th, Stephen LaPlante took the stand against his brother. He said that the day the news broke out about the murders, he told Daniel, quote, "You better not have done it." When the prosecution asked Stephen, who had placed the stolen items in the tool chest in Stephen's home, he said, quote, "My brother Danny did." These items did have Daniel's fingerprints on them. He also said that Daniel did own a similar pair of gloves to the ones found at the scene of the crime. He also went on to call Daniel's alibi into question, as he said that he did not see Daniel at the house during the time of the murders. The next day, Elaine took the stand to tell the jury that she had been coerced into earlier statements she made that identified the blue plaid shirt as belonging to her husband and being a shirt that Daniel would wear. She claimed that the assistant district attorney had told her before her earlier testimony that the shirt and gloves had already been identified as Daniel's. Quote, "He said it was already positively identified, and if I tried to lie about it, I was going to jail for life." She said that she had at one point purchased a pair of work gloves that Daniel used, but the gloves she'd bought did not match the ones used in the murders. She did not point out which assistant district attorney had made these threats, but she did say that she and David still believed that Daniel is innocent. When Riley began questioning her again, she relented and took back her statement, tearfully saying that she had actually told the truth the first time. She was clearly distressed, and Barton ordered both parties to stop questioning Elaine. Riley, as the assistant district attorney, who, though he was not specifically named, would have been the one who threatened her if she was telling the truth, denied these allegations to the media. He told the press, quote, "I told the whole family, 3 people are dead, and we're going to get to the bottom of this one way or another. And if any of you lie, you will be prosecuted." Sheketoff told the media that he wasn't sure if these claims would really help his client at all, quote, "because any trial jury will believe that a person's first testimony is more credible, and that here was a mother trying to protect her child. But he hoped it might at least place some doubt in their minds about the reliability of the family's testimony, as many were testifying for the prosecution." Matthew LaPlante, Daniel's 13-year-old brother, took the stand next. He testified that when he got home at around 2:45 p.m., neither of his older brothers were home. Matthew left soon after to visit a friend, and when he returned briefly at around 4 p.m. to pick up a video game, Daniel was still gone. Elaine corroborated this. She said she didn't see Daniel around the house until 5 p.m. Both she and Matthew specified that they hadn't been looking for him, though. Stephen said that he didn't see Daniel until about 5:20 p.m., but when cross-examined, he had difficulty remembering what happened on December 1st versus the 2nd. At another point during the trial, Stephen said that when he got home a little after 4, Daniel was not home, but Daniel came home at around 4:45 p.m. This conflicting statement was said to corroborate the Pulaski's testimony, as that's when Pulaski claimed that LaPlante came back to the house. David took the stand the next day. He started by weighing in with his opinion on the shirt. He said that he'd signed an affidavit agreeing that the shirt found was similar to one that he had owned. However, when he re-examined the shirt, it was too big. The shirt he had had shrunk in the washer. He also hadn't ever actually said that it was definitely the shirt, just that he'd owned a similar blue plaid shirt. Despite testifying for the prosecution, Daniel's parents took every opportunity to tell the media that they believed he was innocent. They sat behind him every day in court as he stared off into space or smiled to himself, rarely looking directly at whoever was testifying. On October 14th, Michael Pulaski took the stand. He testified that he had been the one to sell Daniel the bullets used in the slayings. Quote, "I gave him the bullets at the very end of November. I trusted him not to do anything harmful with them." Pulaski said that he lied during initial testimony about giving the bullets to LaPlante, quote, "because I was afraid they were involved in the murder." When questioned about why he had the bullets and where he had gotten them from, he said they were for a handgun he owned. He'd bought the gun and ammo from a door-to-door salesman who he suspected may have been pawning stolen merchandise. He agreed to confess to selling LaPlante the possibly stolen bullets only after being promised that he would not face charges for possessing a weapon without a permit. Pulaski took the stand the next day as LaPlante's lawyers were trying to build a defense that Michael Pulaski and/or Stephen LaPlante could have been responsible for the slayings. Sheketoff argued that Michael Pulaski, quote, "certainly could have committed the crime. I'm not saying he did, I'm saying that he had access to everything involved." Both men have alibis for the day in question. Stephen had been marked in attendance at his college class that day, and Michael Pulaski's work showed that he was clocked in that day. But both had given inconsistent statements, including Pulaski's initial denial of giving LaPlante ammo, as well as Stephen being unable to determine exactly when he saw LaPlante come home on the day in question. Sheketoff tried to discredit Stephen and Michael as unreliable witnesses because they had both admitted to hanging out together the afternoon of December 1st and watching TV while smoking marijuana at the LaPlante house. The second week of the trial brought about a barrage of physical evidence that could possibly link LaPlante to the crime. DNA testing was still somewhat new at this time, so it was not used in this case, but forensic experts still put together a convincing argument. They used a mixture of facts and emotional testimony. State Trooper Philip Langdon put on the work gloves found near the scene of the crime, which had gunpowder residue on them, and in front of the jury he cut open a pillow, placed the murder weapon inside, and fired twice to demonstrate how Priscilla had been executed. A crime lab expert from the FBI placed LaPlante at the scene of the crime when he testified that the sneakers worn by LaPlante during his arrest could have made the footprints found outside the Gustafson house, and that the footprints had to have been made that afternoon, as it had been raining earlier in the day. Though LaPlante was not being charged with rape or sexual assault, evidence from that possible crime was still being used to tie him to the scene. The semen stain found was from someone with type A blood. LaPlante had type A blood, and all of the Gustafsons have type O. Thomas Riley speculated in court that LaPlante knew to cover up the assault after he'd been acquitted of rape earlier that year. One of the key pieces of evidence was a hair found on a wet athletic sock in LaPlante's bedroom that appeared to match Abigail's hair. Carolyn LeClaire, a chemist with the crime lab, testified that she observed the hairs to be, quote, similar in every fashion, according to the microscopic characteristics of that hair when compared to Abigail's hair. There was also one of Andrew's ties that appeared to have some of Abigail's hair in it, indicating that it may have been used as a gag. Much of the other evidence came from the clothes that LaPlante had allegedly been wearing the day of the murders. Michael Pulaski testified that on December 1st, he had seen LaPlante wearing a striped shirt inside out along with gray sweatpants. No one else backed up this claim except Stephen. When Michael asked why Daniel was wearing the shirt inside out, he said it was because it made the shirt look more inconspicuous. LeClaire testified that she'd found bloodstains on the socks LaPlante was allegedly wearing, one of which was still damp. LeClaire could not determine if the blood found on the socks was human blood or not. There were also bloodstains found on the gray sweatpants and striped shirt. The bloodstains were on the inside of the shirt, and they were too small to test for the blood type, but they were human, as were the stains on the sweatpants. FBI chemists testified that fibers found on the clothing Daniel allegedly wore the day of the murders matched fibers from the clothing used to tie up Priscilla, and also from fibers found on one of the children who had both struggled with their attacker. These same fibers were found on the gun holster when it was finally found. The clothes LaPlante was claimed to be wearing also had fibers from the flannel found in the woods. Perhaps most damning of all, according to a Boston Herald article, the state crime lab expert testified that when she examined LaPlante on December 3rd, after he was apprehended, he had claw marks on his, quote, face, neck, and back, and cuts on both of his hands. On October 20th, after much of the testimony had already concluded, LaPlante's defense team attempted to convince the judge to allow them to educate the jury on the nature of insanity. They were not pleading insanity, but they wanted the jury to be educated about it, because they said that whoever committed the crime must have been insane. Judge Barton denied this proposal, as the team was not pursuing an insanity defense and was still trying to prove their client was innocent. Near the end of the trial, Sheketoff cautioned the jury against letting their emotions about the horrific nature of this crime keep them from being objective. He said that the jury should absolutely take the scientific evidence into account, but it was important to understand that the evidence had not proven that Daniel LaPlante was definitely the one who did it. Rather, it merely said that he could have been the one to do it. Quote, scientific evidence has an aura of believability. There is scientific evidence that says, you are the one, and there is scientific evidence that says you might be the one. He once again reiterated the possibility that LaPlante was a scapegoat for either his brother Stephen or Michael Pulaski. Sheketoff said, quote, there is a lot of circumstantial evidence, but the problem with circumstantial evidence is that it convicts the House and not my client. He went on to say, quote, there is something weird going on in that family. I suggest to you the operating phrase in that family is, quote, blame it on Daniel. LaPlante never took the stand in his own defense, so the statements that he'd made after his arrest on December 3rd, but prior to having his Miranda rights read, were not made admissible as evidence. Though the prosecution was aiming to release these statements, the one line that had been leaked to the public was that he'd said, quote, "I broke in before, but didn't kill anyone." The defense fought to keep these statements out of evidence, so they apparently did not think these statements would help their client. On October 21st, both the prosecution and defense rested their cases. The defense did not make an opening statement or call any witnesses. The prosecution closed after calling in 2 forensic pathologists, who confirmed that William had bruises and minor injuries indicating a struggle, and Abigail had been beaten and choked prior to her death. Both children may have taken several minutes to drown. In response to the prosecution's emotionally charged closing testimony, the defense offered no closing statements beyond saying that the prosecution did not prove their case beyond a reasonable doubt. Over the course of the trial, 224 pieces of evidence were introduced, and 40 witnesses allied to the stand, the bulk of which was brought in by the prosecution. Judge Barton told the jury that second-degree murder was also a possibility should they find that plausible. The jury deliberated for just 5 hours over the course of 2 days before finding LaPlante guilty. On October 25th, the jury filed into the courtroom one last time. As Barton prepared to read the verdict, he told LaPlante to, quote, "Stand up and face your country, sir." Judge Barton said, quote, "There are some who would say that you should receive the same sentence you imposed on the Gustafson family, that is, death by ligature or hanging. But we have no death penalty in Massachusetts. Accordingly, the sentence to be imposed is one that intends that you spend the rest of your natural life behind bars with no parole, no commutation, and no furloughs. That is 3 consecutive life sentences." Andrew Gustafson had returned to court for the first time since the day of his testimony. As the verdict was read, he held the hands of Priscilla's sisters. He did not answer the reporters who hounded him after the trial. Tom Riley told reporters, quote, "This has been terrible for him. He asked that you respect his privacy." His sisters-in-law told reporters that there really wasn't justice done, as nothing could bring back Priscilla, and they remarked that really 4 lives had been lost that day, as Priscilla had been expecting. Judge Barton later told the media, quote, "Never in my experience have I seen such a heinous crime. The defendant has never shown the slightest bit of remorse for the people who died because they got in his way." Joe Lawless said the Gustafson murders were, quote, "the most gruesome, the most heinous crime, the most vicious crime I ever saw, and I hope I never see another one." Riley, when the verdict was announced, said that, quote, "Daniel LaPlante is a very, very dangerous person, and he'll be a dangerous person until the day he dies. This is the best case for the death penalty I've ever seen. In my belief, he will be a cold-blooded killer until the day he dies. The sooner he dies, the better." After LaPlante was locked up, many people in the town told reporters that it wasn't really a victory. They'd still lost a beloved family and a sense of safety in the community. For some, the trouble was that someone they had known was capable of murder. High schooler Ellen Dorsey said, quote, "It's unsettling. You grow up knowing somebody. I used to play soccer with him," though she added that she thought, quote, "He's got a destructive personality." For others, when the trial was over with, there was not as much closure as they had wanted. Reverend Neil Lund said, quote, "In a society that lives in terms of victory and loss and focuses so much on winning, I don't think there's any sense of winning today. There's a sense of relief and a sense of sadness. You've got 3 lives that have been destroyed and a 4th life that lies in shambles. Justice, it's important, but it's kind of empty." Just months later, on January 1st of 1989, Andrew remarried to a woman he went to church with, Carol Seaver. Carol was a widow as well. her husband had passed away 3 years prior from a brain tumor. Reverend Neil Lund said, quote, "By some standards, it seems very, very quick. Their feeling was that this was other people's problem. With all the family members and local church members on board, it was really only the public or casual acquaintances who might be quick to judge anyway. Their wedding brought together not only their families, but Priscilla's family as well as the family of Carol's late husband. They described it as more of a merging of 4 families, rather than the traditional 2. The church and town were happy for them, and they both had kept their old wedding rings, adding their new ones in place next to them as a reminder of the loves they had lost." A year later, the couple did an interview with the LA Times. Carol remarked that there had been a few people against their marriage, saying, quote, "There were a few people in town that were just aghast. But when you've gone through this kind of loss, you're just glad the sun is shining every day. Life becomes more precious to you. We didn't want to waste it." Carol and Andy still mourn and talk about her husband and his family. Andy went on to tell the Times that his family had visited him in his dreams. Quote, "Each of them came to me in individual dreams and told me that they were all right. It made me believe in an afterlife. That helped me accept their deaths a lot." As of the time the article was written, Andrew and Carol had adopted 2 daughters together. Living with this new family, and 2 years after the loss of his old one, he'd finally reached a point where he could bring out and look through the photos he had of Priscilla and the children. Priscilla had been deeply religious, and had gotten Andrew to be as well, and he threw himself into religion even more after her death. As a reminder of Priscilla's faith, he had the verse, quote, "The light shines in the darkness, and the darkness has not overcome it," engraved on the family headstone. Music is provided by Hexsystem. Major sources for this episode include Parkaman.com, the Boston Herald, the Boston Globe, and the Nashua Telegraph. For a full list of our sources and links to our contributors, please see our show notes. Follow us on Twitter or Instagram at CompulsionCast to stay up to date on our latest episodes and news. See you in 2 weeks.